Remember when we explained that the Supreme Court made presidents theoretically immune from basically any criminal prosecution? Well, apparently Jack Smith didn't get the memo because he's moving full steam ahead in DC and Florida. He's giving the middle finger to Judge Cannon and filing a very interesting superseding indictment in DC. He's playing a game of chicken with the Supreme Court, daring them to stick to their immunity ruling when they really don't want to deal with the implication of the Trump prosecution. Chaos lawyer Liz Dye explains, so I don't have to.
Thanks, Devin. Special counsel Jack Smith came out swinging in the last week of August. First, he explained to the 11th Circuit why Judge Aileen Cannon was entirely wrong to dismiss the stolen documents case. Then he filed a superseding indictment in the election interference case, taking into account the Supreme Court's ruling that presidents can do crimes as long as they do them in an official capacity. It's widely assumed that Donald Trump will simply kill the cases if he gets reelected and brings the Justice League to the White House. So these latest filings are a roadmap of what will happen in 2025 if Vice President Harris wins in November and lets the special counsel get on with his work. On July 15th, Judge Aileen Cannon dismissed the documents case against Donald Trump and his aides, Walt Nauta and Carlos de Oliveira. The three were charged with concealing documents relating to U.S. national security that Trump had swiped from the White House and, in defiance of a grand jury subpoena, refused to give back. Come for the boxes of documents hidden in the shower, stay for the two hapless underlings wandering through the tunnels under Mar-a-Lago, shining flashlights at the security cameras and plotting to delete the footage. You know those Home Alone movies? Yeah, it was basically like that, but in Florida. Back in 2022, Judge Cannon let Trump delay the investigation with a misbegotten challenge to the search warrant that kicked up all those classified documents in his shower. The highly conservative 11th Circuit Court of Appeals put an end to that in a ruling that slammed her legal reasoning as preposterous. So when the case landed back on her docket in June of 2023, a lot of people expected her to find a way to make it go away. I don't think anyone expected it to be because the court decided that special counsels are categorically illegal.
I won the big case in Florida. That was supposed to be the biggest of the cases. I won the big case. I don't know the judge, but the judge was a brilliant judge, strong.
He doesn't remember a judge he appointed to the bench in November of 2020 after he lost the election? Huh. Well, she clearly remembers him. To say that Judge Cannon's ruling was out of left field is a massive understatement. Special and independent counsels have been a feature of American life for decades, including during the Trump administration. In 2017, Attorney General Jeff Sessions appointed Robert Mueller to investigate the Trump campaign's ties with Russia. Trump was furious and fired Sessions the day after the midterms, eventually going on to endorse his opponent, Tommy Tuberville, when Sessions ran to get his old Senate seat back in Alabama. But Trump never suggested that Sessions didn't have the power to appoint Mueller, and he was anything but furious when his second Attorney General, Bill Barr, appointed Special Counsel John Durham to look into the origins of the Mueller investigation, and Special Counsel David Weiss to investigate Hunter Biden. Trump didn't even try to make this argument in D.C., and he didn't make it in Florida until a handful of conservative lawyers filed friend of the court briefs saying, hey, what if special counsels are, unlegal? But Judge Cannon was into it in a big way and even gave those conservative lawyers time to argue the case in court, which is wild. But still, it was a surprise when she seized on this bizarre theory to dismiss the case. In essence, she found that the special counsel is functionally a U.S. attorney, and U.S. attorneys have to be approved by the Senate. And so, when Attorney General Merrick Garland appointed Smith without Senate approval, he violated the Appointments Clause of the Constitution, at least according to Judge Cannon. On August 26, Special Counsel Smith briefed his appeal to the 11th Circuit, and it is a very demure, very mindful curb stomp of Judge Cannon's legal reasoning. He noted that there have been independent and special counsels since the Civil War, and indeed one was used to prosecute Jefferson Davis, the putative president of the Confederacy, for treason, because attempting to overthrow the government used to be a crime.
Where you have every right to do it.
The special counsel noted that the order appointing him referred to various federal statutes, including 28 U.S.C. sections 509, 510, 515, and 533. Specifically, Section 533 says the Attorney General may appoint officials to detect and prosecute crimes against the United States. And Section 515 says each attorney specially retained under authority of the Department of Justice shall be commissioned as special assistant to the Attorney General or special attorney and shall take the oath required by law. That would certainly appear to authorize the Attorney General to appoint special counsels without having to get Senate approval. But Judge Cannon had other ideas. She called Section 515 a logistics-oriented statute that gives technical and procedural content to the position of already retained special attorneys or special assistants within the Department of Justice. And she said those attorneys, again, already retained in the past tense, shall be commissioned, that is, designated or entrusted/tasked to assist in litigation and must take an oath. Nowhere in this sequence does Section 515B give the Attorney General independent power to appoint officers like Special Counsel Smith or anyone else for that matter. As the Special Counsel pointed out in his brief, Judge Cannon seems to be implying that the Attorney General has to hire a lawyer first and then promote him to Special Counsel 5 minutes later. By this logic, Attorney General Garland could have hired Smith for some other purpose and then, after any period of time, perhaps even a second, commissioned him as special counsel, since at that point he would have satisfied the requirement of being already retained. That simply cannot be the law. And as the special counsel pointed out, it certainly wasn't the law in 1974 when Richard Nixon didn't want to turn over the recordings he'd made of himself doing crimes in the White House. Nixon challenged special counsel Leon Jaworski's authority to subpoena the tapes. Like Smith, Jaworski was an outside attorney specially retained by Acting Attorney General Robert Bork. The Nixon court unanimously held that Congress had vested in the Attorney General the power to conduct the criminal litigation of the United States government and to appoint subordinate officers to assist him in the discharge of his duties. And in support of that, the court cited 28 U.S.C. sections 509, 510, 515, and 533. Sound familiar? Judge Cannon shrugged this off as mere dicta, which is law talk for comments made by a judge in an opinion that are not necessary to decide the case. As the special counsel pointed out, if the Attorney General lacked the authority to appoint the special prosecutor, the regulation empowering that prosecutor to represent the sovereign interest of the United States in litigation would have had no force. And while Judge Cannon was willing to dismiss an actual Supreme Court opinion as mere dicta, she was super excited to treat one particular concurring opinion as real law, which again is not a thing. Concurrences don't even rise to the level of dicta. They're non-binding. But in the Supreme Court's immunity ruling, Justice Clarence Thomas penned a concurrence answering a question nobody had asked. The issue was whether Trump could be tried for crimes committed while in office. But Justice Thomas bigfooted in to announce that he was not sure that any office for the special counsel has been established by law as the Constitution required. He called Smith a private citizen who cannot criminally prosecute anyone, let alone a former president. To be clear, no one else signed on to this concurrence, not even Justice Sam Alito. But Judge Cannon, who happily shrugged off the actual holding in the Nixon case, more or less copied Justice Thomas's concurrence and treated it like it was the law of the land. So once again, Special Counsel Smith is asking the 11th Circuit to clean up Judge Cannon's mess before it gets even more out of hand. He warns that Judge Cannon's logic would invalidate the appointment of every member of the Department of Justice who exercises significant authority and occupies a continuing office, other than the few that are specifically identified by statute, and would likewise raise questions about hundreds of appointments throughout the executive branch, including in the Departments of Defense, State, Treasury, and Labor, which all rely on sections resembling Sections 509 and 510 to support their secretary's authority to appoint inferior officers. The 11th Circuit is likely to set this case for oral argument toward the end of 2024. But in the meantime, the election interference case is heating up again. The case against Trump for trying to overturn the election in 2020 has been on ice since December, when Judge Tanya Chutkan denied Trump's motion to dismiss based on presidential immunity. Unlike most legal issues, which can only be appealed when the case is over, presidential immunity is what's known as a threshold question, and the denial was immediately appealable. That's why the case was paused while the appeal wended its way through the courts. The D.C. Circuit agreed with Judge Chutkan that there was no such thing as absolute presidential immunity. But 6 Supreme Court justices, 3 of whom were appointed by Trump himself, decided that presidents are, in fact, above the law. It was a wild, ahistorical ruling. So much so that Devin titled the video on this channel, "We're The court reasoned that forcing the most powerful person on earth to abide by the law might cause him to be chilled from taking the bold and unhesitating action required of an independent executive. So, for things that are his unique constitutional responsibility, the president can't be criminally prosecuted even if those things are crimes, which means that presidents are now free to do stuff like sell pardons. For acts that are within the outer perimeter of his official responsibilities, like making policy speeches, the president enjoys at least a presumptive immunity from criminal prosecution. Trump has taken the position that this covers his efforts to pressure state officials to steal Biden's electoral votes and give them to him. That would include the famous call threatening criminal penalties for Georgia Secretary of State Brad Raffensperger if he didn't magic up just the right number of votes to flip the state. Trump also argued that his tweets riling up his supporters, as well as his speech on the ellipse on January 6, 2021, were official president stuff. Chief Justice Roberts and his fellow conservatives dodged the decision about whether Trump was acting in an official capacity when he urged the mob to march on Congress and fight. The justices conceded that there may be contexts in which the president, notwithstanding the prominence of his position, speaks in an unofficial capacity, perhaps as a candidate for office or party leader. But they blamed the trial court for failing to consider the issue using the rubric they hadn't made up yet back in December. The court was even more skeptical that Trump was acting in a personal capacity when he pressured Mike Pence to reject the real swing state electors and accept the fake ones. The justices concede that Pence was acting as president of the Senate and not part of the executive branch when he opened the envelopes containing the electoral certificates. And they admit that the president plays no role in congressional certification of the election. But they said that applying a criminal prohibition to a president's conversations discussing such matters with the vice president, even though they concern his role as president of the Senate, may well hinder the president's ability to perform his constitutional functions. The court's conservatives did not explain what constitutional functions the president might be performing when asking the vice president to illegally overturn an election. Instead, they held that it is ultimately the government's burden to rebut the presumption of immunity. We therefore remand to the district court to assess in the first instance, with appropriate input from the parties, whether a prosecution involving Trump's alleged attempts to influence the vice president's oversight of the certification proceeding in his capacity as president of the Senate would pose any dangers of intrusion on the authority and functions of the executive branch. And so, special counsel Jack Smith has agreed to take them up on it. If the Supreme Court is going to invent new rules, he'll do his best to play by them and win.
Now, if you tried to subvert the election and kill your vice president, you'd want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've suffered a data breach, especially if you got a data breach letter saying that your social security number has been leaked, were involved in a car crash, or have dealt with sexual harassment from Trump or anyone else, we can represent you or find you the right attorney who can. Because it's so important to talk to a lawyer right away so you can maximize your recovery and get the best representation that you can. So just click on the link in the description or call the phone number that's on screen right now for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. So you click on the link below.
The election case landed back on Judge Chutkan's docket on August 2nd, and she immediately asked the parties how they plan to proceed. The special counsel requested 3 extra weeks to assess the new precedent set forth last month in the Supreme Court's decision in Trump v. United States. Trump, who has demanded that all his prosecutions take place in 2025 or preferably never, happily agreed. But he might not have done that if he'd realized that the prosecution would use that time to convene a brand new grand jury and secure a second pared-down indictment, taking into account the Supreme Court's ruling. The superseding indictment, unsealed on August 27th, contains the exact same 4 counts as the original one. Trump is still charged with obstruction of an official proceeding, conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, and conspiracy against the right to vote and have one's votes counted, since his plan would have involved throwing out about 20 million ballots. The new indictment is 9 pages shorter, thanks largely to the omission of this guy.
Can I put pants on first? Sir, we got to clear the house.
We're going to clear the house, and as soon as we clear the house, we'll get you talking to your lawyer, and we'll get some pants on, okay?
That would be Jeff Clark, who spent the last months of the Trump administration as head of the Justice Department's Civil Division. Clark was an environmental lawyer and not the kind who works for the Sierra Club. He sued the government to block greenhouse gas regulations, and he worked on the team that defended BP after a tanker called the Deepwater Horizon dumped 210 million gallons of oil into the Gulf of Mexico. Clark was definitely not an election lawyer, but he did a lot of research on the internet and decided that there had been fraud in the swing states that cost Trump the election. Again, no, there had not. At Trump's direction, Clark came up with what he called a proof of concept letter addressed to Georgia Governor Brian Kemp, as well as the Speaker of the Georgia House and President of the Senate. The letter claimed, falsely, that the Justice Department had, quote, identified significant concerns that may have affected the outcome of the election in multiple states, including the state of Georgia. It suggested that the Georgia General Assembly should convene in special session so that its legislators are in a position to take additional testimony, receive new evidence, and deliberate on the matter consistent with its duties under the United States Constitution. That is, he wanted to provide state legislators with a pretext to meet up and steal Biden's electoral votes. Clark tried to get his boss, Richard Donahue, the principal deputy attorney general, to send that letter out over his own name. But Donahue said there was no chance he would sign this letter or anything remotely like it, and nor would Attorney General Jeff Rosen. White House counsel Pat Cipollone called the letter a murder-suicide pact that would damage everyone who touches it. So Clark went back to Trump and got the president to agree to fire Rosen and make Clark attorney general. But on January 3rd, 2021, just 3 days before the election was due to be certified, the entire leadership of the Justice Department and the White House counsel's office converged in the Oval Office and threatened that they would all quit if Trump put Clark in charge of the Justice Department.
And he kind of retorted by saying, well, I've done a lot of very complicated appeals and civil litigation, environmental litigation, and things like that. And I said, that's right, you're an environmental lawyer. How about you go back to your office and we'll call you when there's an oil spill?
The Jeff will call you if there's an oil spill episode featured prominently in the original indictment, where Clark was described as co-conspirator for a Justice Department official who worked on civil matters and who, with a defendant, attempted to use the Justice Department to open sham election crime investigations and influence state legislatures with knowingly false claims of election fraud. It made it very clear that Trump knew, because literally every government lawyer but Jeff Clark told him so, that he'd lost the election and that his plan to have the vice president reject electors was wildly illegal.
Did all the people complaining about it point out to you actually did better in Detroit than you did last time? I mean, there's no indication of fraud in Detroit.
But thanks to the Supreme Court, evidence of official acts or counsel from the president's advisors is off limits. So the section captioned "The defendant's attempt to leverage the Justice Department to use deceit to get state officials to replace legitimate electors and electoral votes with defendants" is out completely. The special counsel was also forced to delete all references to people at the White House telling Trump that there was no fraud which could have changed the outcome of the election. But they left in the effort to get Mike Pence to throw out the electoral votes. Smith wrote that the defendant had no official responsibilities related to the certification proceeding, but he did have a personal interest as a candidate in being named the winner of the election. And all of the conversations between the defendant and vice president described below focused on the defendant maintaining power. That is a choice. Chief Justice Roberts invited Smith to rebut the presumption of immunity, and Smith is going to do his level best to do it. And that is going to be a hell of a fight. Meanwhile, Donald Trump is handling the matter in his usual way. Yeah, he's yelling on Truth Social. In order to save face, the illegally appointed special counsel, deranged Jack Smith, has brought a ridiculous new indictment against me, which has all the problems of the old indictment and should be dismissed immediately. He called it shocking for them to do this immediately after our Supreme Court victory on immunity, despite the fact that this is exactly what the Supreme Court told the prosecutors to do. Trump also claimed that it is DOJ policy that the Department of Justice should not take any action that will influence an election within 60 days of that election, but they just have taken such action. Voting starts on September 6th, therefore the DOJ has violated its own policy, election interference. And he demanded that all of these Comrade Kamala Biden hoaxes should be immediately dismissed. Every part of that is just wrong. First of all, there's no rule. It's the Justice Department's internal policy that a prosecutor should never time investigative steps, criminal charges, or statements to affect an election. But it wasn't Jack Smith who timed this thing. It was the Supreme Court who sat on it until the last day of the term, held it for an additional 30 days, and then instructed the prosecutor to go back and amend his case in light of the ruling. Second, a superseding indictment, particularly one that pares down rather than enlarges the original charges, does not violate the rule. Third, the superseding indictment dropped 69 days before the election. And no, you don't start counting backward from the first day someone, somewhere can cast a ballot. And number 4, Vice President Harris has nothing to do with this indictment. That's the whole purpose of having an outside lawyer appointed to bring the case. Nevertheless, House Judiciary Chair Jim Jordan sent Attorney General Garland a nasty letter on August 30th, calling it the initiation of a prosecutorial action by the Biden-Harris administration against its opponent in the upcoming election, and insisting that there is no persuasive argument why Special Counsel Smith could not wait until after the election to file this superseding indictment. Well, that's not law. But I'm sure it's fun to say. Back in the real world, this case is creaking back to life. Both Trump and Smith agree that there will be a knockdown, drag-out fight over whether the Pence evidence can be admitted at trial. The special counsel proposes that the argument over immunity should get started immediately and run parallel to the other motions to dismiss, which were frozen in place by the appeal. Trump proposes not that. He wants to do this thing as slowly as possible. In fact, he'd like the special counsel to say nothing at all until after the election. Instead, he suggests that they should spend the rest of 2024 litigating his motion to dismiss the case based on the theory that the special counsel was illegally appointed. Trump hasn't even filed that motion yet, and arguably, he's waived his right to do it since the deadline for pretrial motions was in October before the Supreme Court froze the case. Judge Chutkan may let him file it anyway, but if she does, it's not likely to take her 4 months to decide since the D.C. Circuit ruled in 2019 that special counsel Robert Mueller's appointment, under the same statutes as Jack Smith, did not violate the Appointments Clause. Told you that Judge Cannon dismissal order was nutso. Trump's proposed scheduling order drops off after the third week in January when the new president will be sworn in, and that's probably not a coincidence. After that, he mumbles about spending spring through fall of 2025 on additional proceedings if necessary. Leaving aside the obvious implication that he intends to win in November and put an end to this case, Trump is probably not crazy to suggest that it will drag on through 2026 if he loses the election, because immunity is a threshold question that can be immediately appealed. Remember, that's how this case got sidetracked in the first place. So unless Judge Chutkan dismisses the case because it includes the Pence pressure campaign, Trump is going to appeal immediately and ask the Supreme Court to bail him out again. But by then, the 11th Circuit may well have returned the documents case to Judge Cannon so she can find some other reason to dismiss it and force Jack Smith to trek back to the 11th Circuit, which means we'll be covering these Trump trials for a long, long time.
But on Thursday, September 5th, Judge Chutkan issued a very interesting scheduling order in the D.C. case that has a bunch of stuff happening long before the election. She basically told the litigants that she's not taking the election into consideration. Jack Smith's opening brief on presidential immunity is set for September 26th, and Trump's response and renewed motion to dismiss are due on October 17th. And maybe most hilariously, Trump has a reply brief on one issue due on November 7th. But maybe he can ask Mike Pence for help. I wonder what happened to that guy. Yeah, ever since Trump tried to kill Mike Pence, he's really fallen off the face of the earth. It's almost like he used today's sponsor, Incogni, which removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If the data brokers refuse, Incogni will take care of that too, because Incogni fights back. These data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. They also might be why you're getting so many spam calls lately, or even why someone might steal your identity. But Incogni is a great way to fight back, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. I've been using Incogni for years. You can see I was on hundreds of lists, some of which had a high sensitivity score, meaning that the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me and is processing dozens of others. If I were to try this myself, it would take hundreds of hours. So thank you, Incogni, for saving me hundreds of hours and adding me to over 40 suppression lists. And the best part is Incogni will continue to conduct ongoing removals, because even if the broker removes your data once, they can collect it again. Incogni makes sure that your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. If you click on the link that's on screen right now or down below, you can try Incogni risk-free for 30 days and get a full refund if you're not into it. But if you are, you can use the code LegalEagle for an exclusive 60% off discount. So to get an exclusive 60% off discount, just click on the link that's on screen right now or down in the description and use the code LegalEagle. After that, click on this link over here for more LegalEagle, or I'll see you in court.